Hi, I'm Joshua Taylor, a partner at Keystone Law Group, a probate firm in Los Angeles. I'm here to talk to you about the rights of a trustee to withdraw money from a trust. The reality is that trustees will have to withdraw money from the trust in order to do their job, but they can only withdraw money for certain reasons, which we will go over in this video. Both trustees and beneficiaries should review the trust instrument with an attorney at the start of administration to understand the full scope of the trustee's financial powers. By taking time to understand the trust, trustees can protect themselves against liabilities, and beneficiaries can protect their inheritances. The terms of the trust instrument provide the rules of trust administration, so it's important to know them inside and out. Next, trustees are not only permitted to access trust accounts that were funded by the settlor prior to their death, but also to open new trust accounts. It is recommended for trustees to open a new trust account at the start of administration to preclude the possibility of their personal assets being commingled with those of the trust, which would be considered a breach of their fiduciary duty. Administration expenses, as well as the trust's and settlor's debts, and ultimately distributions to beneficiaries, can typically be paid from the trust account. But there are exceptions and limitations, so it's best to seek the advice of a trust lawyer about which debts should be paid and what distributions to make and when. As we'll discuss next, trustees are also generally entitled to withdraw money from a trust to cover the cost of third-party professionals helping with administrative duties, which is often an essential component of trust administration expenses. It is common for trustees to hire a trust attorney or CPA to assist with administrative tasks. If the trustee needs to bring or defend a claim related to the trust, they can usually withdraw money to cover attorney's fees and costs. These expenses are often necessary to preserve and protect the trust estate for the beneficiaries. Next, unless doing so is expressly forbidden by the trustee can and often should make safe investments using trust funds. Trustees have a fiduciary duty to make trust property, quote, productive. That means that trustees cannot simply allow money to sit in a non-interest-bearing account for years or allow real estate to sit vacant without being rented. But trustees should also not make investments that are overly risky or from which they could personally gain, as doing so could be regarded a breach of duty. Trustees are also permitted to withdraw money to pay both the settlors and trust creditors. Sometimes the decedent's debts are paid by their estate. Therefore, the trustee is only responsible for paying the debts of the trust. But many times, when settlors die with an active trust, a probate will not be necessary and there will not be a formal probate estate capable of paying the decedent's debts. In most cases, a settlor's trust will provide that the trust should pay the decedent's debts to the extent that there isn't an estate with sufficient assets to do so. A probate attorney can provide further guidance to trustees about which debts the trust has an obligation to repay. Additionally, trustees are entitled to reasonable compensation for the time and energy they spend on administration. If the trust does not provide instructions for compensating the trustee, the probate code provides that the trustee is entitled to, quote, reasonable compensation, but that term is not specifically defined. In order to avoid disagreements with beneficiaries, it is generally preferable for the trustee to be upfront and honest about the way his or her fees are going to be calculated, which is usually based on an hourly rate or a percentage of the value of the trust estate. Next, the trustee is also entitled to withdraw money from a trust to make distributions to beneficiaries. Distributions made to trust beneficiaries must be in accordance with the terms of the trust. For example, some trusts provide for distributions to be made as a lump sum, whereas others call for distributions to be made over time. Whatever the trust specifies must generally be followed by the trustee. That concludes Keystone's video on the right of a trustee to withdraw money from a trust. If you continue to have questions, schedule a free consultation with our experienced probate attorneys by clicking on the link in the caption. Lastly, be sure to subscribe to our channel to be notified when new content has been posted. Thanks for tuning in.